Daryle Tibbs of Tibbs Law Office, talking to you today about the book Splitting. We have read this book and I want to give you my thoughts about it. This book was given to me by a client. The client felt that this book was helpful to her in navigating a case with her husband. It was a divorce case. She believes her husband to be suffering from NPD or BPD, which is narcissistic personality disorder or borderline personality disorder. Splitting is a term used to describe a defense mechanism universally seen in people with BPD and NPD. I definitely have a love-hate relationship with this book. So let me begin by being truthful that it took me a very long time to get through this book. I started the book and got about halfway through the book pretty quickly, and then it took me a long time to pick the book back up to finish it the rest of the way. Part of the reason is because it started to get pretty technical, and obviously as an attorney I'm pretty aware of the procedural portion of the divorce case, and so it was difficult for me to make myself pick the book back up and start reading. Some of the legal-based information is a little bit inaccurate, so I'm going to talk to you a little bit about that today. That's sort of the end of that one. First, this book attempts to address the different types of evaluators that might be pulled into a domestic relations case. One such evaluator it describes is an attorney for the minor children. This label was a little bit frustrating for me because I feel like it is either inaccurate or at the very least misleading. It leads the reader to believe that the book is referring to an attorney representing the minor children, but what I think the book was actually referring to is a guardian ad litem. There's a huge difference between an attorney that's representing someone and a guardian ad litem. So an attorney that is representing a minor child in a case is supposed to advocate for what the child wants. A guardian ad litem is to do an investigation for the court and advocate for what that guardian ad litem believes to be in the best interest of the minor child or children. This book, I think, confuses those terms, and for someone that is not an attorney going through the process, that might be very confusing for them. If the child is going to be represented by an attorney in a case, it's up to the parent to retain counsel to represent that child. The court in a private case, custody case, is not going to appoint an attorney to represent a child. So it would be up to parents to retain someone to do that. The court will, however, appoint a guardian ad litem in a case to represent to the court what the child's best interests are. The entire section about the guardian ad litem or attorney, whichever it's referring to be honest, I'm not sure, but I believe it's referring to the guardian ad litem. I think it's very confusing because additionally, a guardian ad litem's fees would be up for the court to determine who is going to pay those. And so that, for a parent that doesn't understand that process, they might be caught off guard about the fact that the court will be deciding who's going to pay for a guardian ad litem. This book's not all bad though. It provides some great suggestions on how to deal with high tension and a high litigious opposing party. One of the best points made by the author is the fact that highly aggressive attorneys don't often win in the long run. This is important. This is a conversation that I have with my clients. So highly aggressive attorneys like to put on a show for their clients to make their clients think that they're doing a good job. But what I tell my clients is that the things that parties don't realize is that oftentimes the attorneys will go into the judge's chambers beforehand. We are speaking to the judge about whatever the issue is before the court. We are making our arguments to the court, and obviously the court's not hearing all of the testimony and all of the evidence, but the court basically tells us what they might do if the evidence shows what we are telling them that it will show. So by the time our clients come into the courtroom, we've already made those arguments before the judge, and we already know what the judge is thinking in terms of how they might rule on a particular issue. So oftentimes the court will bring the clients in, and we will make those arguments on the record so that there is a record made in case someone wants to object or appeal. But the highly aggressive attorneys will continue to be highly aggressive and will really put on a show for their clients. If you have an attorney that is not highly aggressive and they are sort of sitting there and not really responding so much, not interrupting, things like that, that's because that attorney already knows what the judge is going to do. So that attorney knows what the conversations were. The attorney is going to have an opportunity to speak and will make their points for the record. However, they're not being overly acting in what they're doing for the court. They don't need to do that, especially if they already know that the court is likely to rule in their favor on that particular issue. One of the things we learn as an attorney that's really important is we learn when to speak, but more importantly, we learn when not to speak. So an attorney who is sort of sitting there and not really saying much, there's generally a reason that they're doing that. And that's important for the clients to understand, that just because we may not be advocating, the way that our clients think we should be advocating, or as hard as our clients think we should be advocating, usually there's a reason for that. So keep that in mind. Another great resource and a suggestion made in this book is an open letter to family and friends that they included in the back of the book. The letter is provided as a suggested script of a letter that a person could send to their friends and family, someone who's going through this process and they want to sort of inform their friends and family at least of what they would like their friends and family to know as they're going through this process. I thought the letters were good. With some modifications, the letters can be used for almost any type of divorce, and in a high tension, highly litigious divorce, a letter like this could be a great tool. One of the best pieces of information in the letter is to your friends and family, to ask your friends and family not to take sides in the divorce. By way of example, the letter states, "While siding with me may give me a temporary feeling of satisfaction, it's a form of all or nothing thinking that reinforces seeing one person as all bad and the other as all good." Basically, you're using the letter to ask your friends and family to not talk negatively about your soon-to-be ex, because that leads to deeper feelings of resentment and vindictiveness. And this is a great idea because those feelings usually already exist in abundance and don't need to be reinforced. And I thought that was a great resource that this book provided. Overall, I gave this book 3 stars. I think that the confusion regarding the attorney for the child or the guardian ad litem was a little bit misleading and might be difficult for a client to understand. But overall, I thought there were some great points this book made and some great resources in it.